Welcome to another episode of Take Off Monday, where we discuss topics dealing with entrepreneurship, career transitions, podcasting, and video streaming. Today, we're going to be talking about intellectual property. Our show, Take Off Monday, is meant to give you a 15,000-foot view of a topic. We try to keep our shows to 15 minutes or less so that you can get the little nuggets of useful information that you need. If you want more information than what's provided, then please go to our website, rocketshipconsultants.com. I'll say it again, rocketshipconsultants.com. There you can read our blog, subscribe to our newsletter, and email us to set up a free phone consultation. I'm Rosanna Catalano, an attorney and the owner and founder of Rocketship Consultants. Our company helps clients get to the next level, whether that is with the business they own or in their career. And we help clients looking to create and monetize a video show, podcast, or virtual event. Our team of coaches and consultants can help you focus, prioritize, and inspire you to start making progress on those goals you have been neglecting. And we want you to help you change your trajectory. We help you launch a new and better version of yourself.
We do. The team with Rocketship Consultants is made up of attorneys, and we each bring a unique skill set and experience to our clients to help them achieve their goals, whether it be to launch their careers, their businesses, or their organizations in creative and practical ways. Ro and I recently hosted an informational webinar to guide organizations through the steps to pivot from in-person events to virtual events, and we're always looking ahead to provide creative solutions for our clients. If your organization is looking for innovative ways to grow, maybe through a podcast, a virtual event, or a live stream show like our Take Off Monday show, then contact us.
You know, we have recorded about 20 of these episodes to date. Can you believe that, Joy? And you can find all of them on our YouTube channel at Rocketship Consultants, which is scrolling right at the bottom of your screen. And in a couple of weeks, we'll be wrapping up our focus on business ownership, and we're going to turn our attention to some internal topics dealing with growth. We are going to have some guest speakers and other Rocketship team members. It's going to be great, so be sure to tune in.
Can't wait to hear from some of those guests and can't wait to introduce our audience to our fantastic teammates here at Rocketship. As you said, tonight we're going to talk about intellectual property, IP. Intellectual property refers to things you create with your mind, like inventions, literary and artistic works, designs, and symbols, logos, names, and images used in commerce. Intellectual property is protected through patents, copyright, and trademarks, which let people earn recognition or financial benefit from what they create or invent.
So many businesses, especially tech and healthcare businesses, are based on intellectual property rights that they hold. You know, if Google didn't protect their algorithms by law, then where would they be as a company right now? And boy, I wish I had invested in Google earlier.
No kidding.
But everything in life, you know, nothing's easy. And our IP system has to strike the right balance between the interest of innovators and the wider public interest. Our intellectual property system should aim to foster an environment in which creativity and innovation flourish.
Yes. And entrepreneurs need to make informed decisions about what to protect and what to put in the public domain. If you have intellectual property associated with your business, then you need to speak with an attorney that specializes in intellectual property. That is so important. You definitely want an attorney experienced in this area of law because it is highly specialized. For example, not every licensed attorney can represent you with regards to a patent. I'm not a patent attorney, and I know you aren't one either, Ro.
No, I am not. That is correct. I am not a patent attorney. Trial attorney, yes, but a patent attorney, no way. We don't have the additional qualifications. Joy and I don't have the additional qualifications to practice patent law, which is what a business usually needs if they have an invention or a novel process that they've created. Registered patent practitioners are individuals who have passed the U.S. Patent and Trademark Office's registration exam and met the qualifications to represent patent applicants before the U.S. Patent and Trademark Office. Many of these intellectual property attorneys have backgrounds in science and engineering.
Protecting intellectual property assets and knowing when to forego protection requires entrepreneurs to be proactive. And this is where experienced counsel can really provide you the guidance that you need. Let's take a quick commercial break. And when we come back, we can talk about trade secrets, copyright basics, and trademarks.
At Rocket Ship Consultants, our mission is to launch your business, career, or podcast. Our team works with you to start and grow your business with fresh ideas and inspiration. Let us make key introductions on your behalf and leverage our network of contacts. Talk to us before you send your application in for a new position, a university admission, or a scholarship. From resumes and interview preparation to negotiating offers, our experienced career advisors can help you at all levels achieve your career goals. Let us help you take that dream you have for a podcast or video and turn it into a reality. Rocket Ship Consultants offers a variety of services, so check out our website at rocketshipconsultants.com. Take off with Rocket Ship Consultants and launch your business, career, or podcast with us.
Welcome back. If you're just joining us, we're talking about intellectual property on this episode. We should discuss trade secrets because more businesses have important confidential information that helps them to compete in the marketplace. Once competitors get a hold of your trade secrets, then your company's value diminishes in the marketplace.
Exactly, which is why companies should have a non-disclosure agreement or a confidentiality agreement with their employees. On top of that, there are some federal laws that help protect trade secrets. For years, the Uniform Trade Secrets Act provided, or should I say, served as a model statute for the laws in almost every state. However, despite its name, the Uniform Trade Secrets Act, it did not lead to a uniform set of laws, as many states adopted their own variations. And of course, court opinions ended up creating separate bodies of law for each state version. So to remedy this so-called patchwork of trade secrets law out there, the Federal Defend Trade Secrets Act was enacted in 2016. And what you need to know is that broad types of information are protectable. Sales and marketing plans, customer lists and data, software, computer files, manufacturing techniques, formulas, recipes, research and development results, survey information, sales data, secrets embodied in products, circuits on computer chips, and almost any other type of information can qualify as a trade secret as long as this information gives your business a competitive advantage and is not generally known or discoverable through proper means by competitors. And the biggest risk to you as an entrepreneur would be failing to take appropriate measures to protect less obvious forms of trade secrets and thereby losing your trade secret protection.
Yes, that covers so much, and you want to be protected. And so this is where the advice of an intellectual property attorney is extremely helpful. What business owners have to realize is that once this private information becomes public, once the cat's out of the bag, it is no longer a trade secret. Although you could sue for damages, the wrongdoers may not be able to pay for their wrongdoing. And then you are stuck with no real recourse to make yourself or your business whole again. So basically, your best course of action is to prevent both the improper and inadvertent trade secret disclosure. You need to take reasonable efforts to maintain secrecy and your trade secrets. You'll want to create a trade secret protection program with the advice of your attorney. You will want a way to, 1, identify trade secrets in your business, and 2, secure employee commitments through pre-employment checks, non-disclosure agreements, non-compete agreements, and employee training.
You will also want to discuss things like email encryption, clean desk policies, keeping records of what software was checked out to whom and when, use a paper shredder and restrict access to files. All of those things can be part of your plan. And we're just scratching the surface here. We could talk for days on this topic, but we wanted to give you that 15,000 foot view we mentioned at the beginning of the show. The next thing we should discuss is copyrights for your business. A copyright gives an entrepreneur or owner of an original work of authorship the exclusive legal right to obtain certain economic benefits from the work. And copyrights, can protect works of art, musical recordings, magazines, plays, graphic designs, instruction manuals, software, financial tables, pitch decks, and even shows like ours.
Copyrights also protect derivative works and some compilations. A derivative work is one that's based on another. It's like adaptations and modifications. But remember that copyrights don't protect ideas. They only protect the particular way the idea is expressed in a tangible medium or expression. The advantage of a copyright is its duration. The copyright for an individual creator lasts for the life of the creator plus 70 years. For a work made for hire, which is when an employer owns work that's created by an employee within the scope of their employment, the duration is 95 years from the year of publication or 120 years from the year of creation, whichever is shorter.
Wow. And I wanted to circle back to patents tonight. Patents can provide you with protections for inventions and give you and your company exclusive rights. Patents are granted in the United States by our federal government, and they entitle you to prevent anyone else from making, using, selling, or offering to sell the patented invention in the United States for a specified period of time. Other companies, other countries, I should say, have similar but not identical definitions. There are different kinds of patents, utility patents and design patents, and we can't emphasize enough how you should work with an experienced intellectual property attorney that handles patents. The attorney will help you with filing the patent application and walk you through the process.
That's good to know. Having that specialization and going to somebody with that specialization is extremely important. We cannot emphasize that enough. Lastly, we should discuss trademarks. A trademark is any word, phrase, name, symbol, even a sound, or a design that identifies and distinguishes one company's products from those made or sold by a competitor. Some famous trademarks that you're probably familiar with are the swoosh symbol on the Nike sneakers, or even the chime that you hear when you watch the NBC network. Federal trademark registration lasts for 10 years, but the owner can prove continued use between the 5th and 6th years. If you show a continued use and you meet certain requirements, then your trademark registration can be renewed indefinitely for increments of 10 years.
Well, that wraps up another Takeoff Monday. Remember, we stream live every Monday night at 8 p.m. to the Rocket Ship Consultants Facebook page, YouTube channel, and to my personal LinkedIn profile, Rosanna Catalano. If you want more information than what was provided in today's episode, then please go to our website, rocketshipconsultants.com. I'll say it again, rocketshipconsultants.com. There you can read our blog, subscribe to our newsletter, and call us to set up your free consultation. Is there anything else we should tell our audience, Joy?
Of course. You know that we produce a number of video shows and podcasts for other companies and groups. This week, you don't want to miss the Florida's Women in Energy Leadership Forum show on Thursday at 2:30 p.m. Attorney Lila Jaber will be interviewing Cynthia Barber with the City of Tallahassee and Monica Marlowe with the Lake Apopka Natural Gas District. Be sure to tune in for that. Follow our company on social media. You can find us on Instagram, Facebook, Twitter, and LinkedIn at Rocket Ship Consultants. If you have a future topic suggestion for our show, be sure to put them in the comments below. And please let us know if you or your business would like to sponsor our show. We have sponsorships available, so give us a call. Our contact information will be up at the end of the show. That wraps up this episode on intellectual property. Good night, everybody.
Good night.